Confirm, right?
Yeah.
Okay, so how would we do that?
Well, that's what we're doing right now. So I sent you that email. I looked at your amended complaint. I sent you the email yesterday
Yes.
identifying, what we still see as issues with the complaint. And, it's our opinion that you really can't overcome those issues. And so I wanted to discuss that with you because ultimately what I'm asking is that you dismiss the complaint. And the reason for that is I did not put this in my email to you, but I can put it in an email to you today. But on the face of your complaint, from what I gather, you're claiming that you disclosed the tablet, it's an unspecified tablet, to someone at Apple back in 2010. And the statute of limitations on a misappropriation claim is 3 years. So let me go back to my email here. Your complaint says that you wrote Apple in 2011. But you don't say what they. I'm not going to lie, Mr. Super Wilson. I'm having a very difficult time following your complaint. But from what you can expect the demur to say is that there's a couple reasons why we believe your complaint is subject to a demur. The first is that it's, in our opinion, it's unintelligible. There's a lot of information that's missing, and when I read it multiple times, it just doesn't make sense to me. For example, you say, I wrote Apple in 2011 and they sent me an auto reply. You don't say what you wrote. You don't say, what information was in that communication. There's anything about that, about like a misappropriation claim or that you disclose a trade secret. So that's one. I think the complaint as a whole is uncertain is the phrasing they use. It's an uncertain pleading. And so we would object on that basis. The second basis would be that you haven't identified a trade secret, which is a necessary pleading requirement for a misappropriation claim. And the third is that the statute of limitations bars your claim. So on the face of your complaint, it seems like you're suggesting that you said something to Apple in 2011. I'm not sure
I
what
didn't
that
send anything
was.
to Apple.
Well, your complaint says, I wrote Apple in 2011. They
Yes.
sent me an auto reply.
That letter is part of the evidence. And I will be disclosing that during the discovery.
Okay. Well, our position is that, you haven't, the complaint is uncertain because you haven't identified what entitles you to a misappropriation claim. There hasn't been a trade secret identified that Apple's. I take it that your complaint is that Apple stole a trade secret from you and then made money off of it.
No, they didn't steal it from me. They got it from someone, the inventor's hotline. And yeah, that's part of the cutsa. But there's more to it. I just want to be heard for the most part. And there's going to be a hearing, right?
Yes. So if we pursue the demur, which we're planning to do, there will be a demur hearing.
Mm-hmm.
The way that works is, are you in California?
No.
So in California, the court will issue a tentative ruling. We'll file the demur. You're going to have a chance to respond to our demur.
Right.
And then we're going to have a chance to reply to your opposition. And then the court will issue a tentative ruling. And if you want to challenge the tentative, then there will be a hearing.
Oh, so the hearing comes after the ruling.
Well, it's called a tentative ruling. So the court will issue what's called a tentative ruling saying, I've read the papers. here's how I intend to rule. And then if you want to contest that tentative ruling, you can. And if you don't, then the tentative ruling becomes the actual ruling.
Okay.
But so I just want to go back to our claims or our arguments, because this will be important, and we just have to make sure that we're on the same page about this.
Okay.
So, one, we think that the complaint is subject to a demur because you haven't identified any trade secret. Two, the complaint is uncertain. It doesn't. It's not clear like what you're asking for or like what you're fighting over. And then three, it's barred by the statute of limitations. So, I mean, I'm not sure how to read the complaint in relation to what you just said about the inventors hotline. I don't know what that is. But from the complaint, it sounds like there was some sort of communication or correspondence that happened in 2011. And then Apple proceeded to sell a bunch of tablets, and they made a bunch of money off of the tablets. And you're claiming you're entitled to some of that money. Is that right?
Something like that, yeah.
So under that fact pattern that you've written in your complaint, you had until 2014 to file this complaint. That's the statute of limitations. So, you know, Apple stole this. You were aware that they stole this information. Like, you knew what a tablet was. They were selling it, and then you waited 14 years instead to file the complaint. So this relates to my last point, which is, you know, the California, what does it stand for? I should know. The California Uniform Trade Secrets Act, it allows a court to hold the other side responsible for attorney fees on behalf of the prevailing party. So if it finds that you filed this complaint in bad faith, and are you familiar with that concept of bad faith?
No, not really.
So the concept of bad faith is, you know that you don't have a valid claim against Apple, but you're filing it anyway. That's an example of bad faith, right? Like, you know that your claim isn't a valid claim, right? Which in this circumstance, I think there's a very, very strong argument that it's not valid because you're way past the statute of limitations. And so the court's going to say, as a matter of law, you can't bring this claim. And, you know, I'm making you aware of that because I'm telling you, hey, the California Uniform Trade Secrets Act allows the court to impose attorney's fees on the other side, on the losing party, basically.
Okay.
Right? So if we file the demur and we're successful, we can ask the court to recover attorney's fees for having to file the demur in the first place because you knew it wasn't a valid claim and you still proceeded to bring it in bad faith.
Well, it's not bad faith. I just have to get my evidence out there. And I can do that at the hearing.
Well, I mean, the question would be that the court should ask, why did you wait 14 years to file this complaint?
I have an answer for that.
Okay. And so, I mean, are you willing to share that information or?
No.
Okay. All right. Well, so I take it you're not going to dismiss your complaint?
No.
Okay. Are you intending on amending the complaint at all?
I already did that.
Right. Well, I mean, in light of what I told you today, is there anything that you want to amend?
No. I'm just going to go through with it because I want to be heard.
Okay. All right. Well, I think that's it. You know, we've done our meet and confer. I told you what the issues are, and it sounds like you're not going to amend it, and you're going to continue on.
Right, because y'all take too long to reply.
Okay.
I I think y'all waited like 20 days the last time, right? And then you just responded to me yesterday, and yeah, about 20 days. You know, I sent you a message and I asked, were y'all still going to whatchamacallit? And it sat there for a minute. It really did. And I'm like, I'm not trying to sit there and bother you or anything, sir. But yeah, I'm gonna leave it like it is.
Okay. All right. Well, do you have any questions for me, or I think we're all set then?
Why are you coaching me?
I don't know what you mean.
Okay, so like normally somebody, like when they have a specific profession, they do ABC XYZ, but you do M, N, and O in the middle.
I'm not following you.
Oh, okay. So you don't understand the way that I talk. Okay, I got it.
I don't know when you say why. I don't. When you say I'm coaching you, I don't know what you mean by that.
Yeah, coaching.
Can you like? I'm not sure what you mean. How am I coaching you?
I can't really explain it. But I feel like I'm being coached.
I'm. The whole thing is, you're entitled to do what you want to do with this lawsuit. It's your choice.
Right,
The code forces us to have this phone call. And
right.
so if we identify issues with your complaint that we think are subject to a demur, we're obligated to explain what those issues are to you. And it gives you an opportunity to fix the issues if it's possible to fix them, so that we don't waste the court's time and resources. That's the whole point of this process.
Mm-hmm.
And so all I'm doing is I'm saying, hey, I've looked at your complaint. I've tried to understand what your complaint is saying. I frankly, I'm not insulting. I'm not trying to insult you. I'm just saying I'm not following the complaint. I don't understand what your claim is or why you think you're entitled to $3 billion. But that's beside the point. The whole point of this call is to say, like, Mr. Super Wilson, here's here are the issues that I've identified in your complaint. If you can fix them, you should fix them. And if not, then we have to file the demur. That's the whole only point of this call. So I'm not trying to coach you. I'm not trying to persuade you to do one thing or the other. But one of the things I am saying is that on the face of the complaint, it doesn't look like you have a valid claim, right? For, I think, several reasons. But the most prominent one, and the thing that I think the court will latch onto, is that your complaint is very untimely. Under the statute, you have to bring the complaint within 3 years, and you brought it within 14 years, so it's way past it.
Yeah,
And
I know. I have another question for you though.
okay.
Okay, do you know about the policies of Apple?
I mean, I know some, but it's not really relevant for what our conversation is today.
Okay, I was just wondering.
Okay. All right. So I don't want you to be offended by this conversation. I don't want you to think that I'm coaching you. I'm just trying to do my job here, and treat you fairly in this lawsuit. So we'll proceed with the demur, and yeah, I think that's it.
Okay.
Okay. All right. Well, thank you very much, Mr. Super Wilson, and you'll get those papers shortly. I think we have a few more days to file those.
All right. Thank you.
Okay. Bye-bye.
Hello?